I'm Ernie Manous, and this is a truncated version of Town Square. Today we are following breaking news. Former President Donald Trump appeared in court for his arraignment in a case involving how hush money payments made to an adult film star were handled and falsification of business records, and the relationship of this behavior to the 2016 presidential campaign. Will the former president be found guilty and held accountable, or is this, as he's claiming, political persecution? Our panel is here to break down the latest and to take your calls, questions, and comments. What were your reactions to the news you just saw unfolding right here on the air? Retired U.S. District Judge Vanessa Gilmore. Judge Gilmore, welcome back to the program.
Good afternoon, Ernie.
Judge, let me start with you. I listen to all this, I hear all of this, and I hear this cry from people out there saying, sounds like a paperwork problem to me. Why is this something more than a paperwork problem?
Well, apparently, as the New York District Attorney just explained in his press conference, it is a violation of New York law and something that apparently his office prosecutes on a regular basis to preserve the integrity of the business system in New York. It has to be, in this particular instance, tied to other crimes, and he set out what he believes he will be able to prove are the other crimes that are related to the falsification of business records here, that it was to support a candidacy of a candidate through unlawful means, that it violates the cap on contribution limits, and that somehow or another it violates tax laws in terms of disclosing these particular payments. And so in this instance, the district attorney has set out why he believes that it's more than just a paperwork problem.
Judge Gilmore, let me ask you, if you can sum up so our audience understands, our listeners understand, what exactly is the point here? We heard there were 34 indictments. We heard that it had to do with Karen McDougal and Stormy Daniels and supposedly this child out of wedlock. What actually is the basis of what we're listening to today?
Well, often prosecutors will have multiple count indictments that account for every check that was written, every use of the wire in a wire transfer case. The practical reality of it is that, generally speaking, the facts are not different for each count. There is generally one fact, and that there are just multiple times that there was a transaction related to those facts. For instance, I tried one of the Enron cases in which we had an indictment with over 200 counts in the indictment. Ultimately, it doesn't matter that much in terms of sentencing because for purposes of sentencing, all of them are sort of grouped together, and there's not 34 separate opportunities for the person to be convicted or to have a punishment assessed against them. It's grouped together at the end.
I want to remind everyone we are talking with retired U.S. District Judge Vanessa Gilmore, and this is Town Square. I'm Ernie Manous. Judge Gilmore, let me go back to what you were talking about a minute ago that kind of plays off of what Dr. Sorrentino just said. So if there is the case of the way the payments of money were paid to Stormy Daniels, which seems like one set of issues, if you've got the catch and kill stories that happen to be with Susan McDougal or Karen McDougal, and also with the baby story, those seem like very different tracks of behavior and crimes, if you want to use that term for it. How do all of these end up lumped together?
From all that I can determine, it all relates...
Yes, let me just say real quickly, we're just getting all this information. You guys really are very good sports to come on and analyze before we've had enough time to really process everything.
Exactly.
But that said, please continue.
But from all that I can determine, it all still relates to falsifying business records in the same set or types of checks and related to the same three underlying New York State crimes. And so it would make sense that these would all be in the same indictment. But back to my earlier point, I know I'm sorry that my connection wasn't that good a moment ago. 34 different counts just means this is how many times a check or some instrument was exchanged or written that resulted in falsification of records. It can sometimes be problematic to have multiple count indictments because you have to prove every single count with evidence before the jury, and sometimes that can be difficult. It doesn't seem like in this case it would be that difficult because it's just a series of this. Here's a check, here's another check, here's another check. So it might not be quite as complicated as it would be in other types of cases.
Mm-hmm. Judge, talk to me a little bit about the idea of misdemeanor to felony. And Lady Justice is supposed to be blind.
Well, this is a whole new thing, I guess, is for all of us to see how this works under New York state law, where they can take crimes that ordinarily would be misdemeanors, but because one crime supports the commission of another crime, that elevates it to a status. And so apparently that is the way that they are pursuing and prosecuting this case in this particular instance. But in terms of the whole idea of Lady Justice being blind, I think that the fact that a grand jury of 23 people, at least 16 of whom had to be present to deliberate, and 12 of whom had to vote to have a true bill, showed that there was probable cause to believe that a crime has been committed. We haven't seen the evidence. We don't know what it is. And for us to be pontificating on whether or not there is a basis for prosecution of this claim based on the few little sound bites and the brief glimpse that we've all had a few minutes ago at the indictment, when this grand jury met for weeks and weeks poring over evidence, I think is a little bit presumptuous of any of us, because we haven't seen the evidence. I often had trials where I saw reports about my case in the newspaper after the fact, and I thought, were they in the same courtroom? Did they read the document?
Yeah.
So I think that we'll just have to wait, like the district attorney said, to see what the evidence bears out.
Yaya wrote into us to say, if ex-president posted a picture on his social media with a baseball bat near a picture of a public official in New York, which many people perceive as a threat toward those officials during the time of this arraignment, wouldn't that in itself be a crime? Judge, your thoughts?
It could be. Obviously, it could be. Do I think anybody's going down that road? I doubt it. I mean, I think that'd be a waste of time. There are bigger fish to fry.
Let me ask you a question that doesn't really tie directly to this, but I'm curious. If you have a defendant in front of you and you're on the bench, I'm curious, the behavior we've seen exhibited by a person like Donald Trump, how do you handle that in a court? And what kind of punishment, if Trump, he's supposed to have a press conference or a statement this evening, if he starts, for lack of better words, shooting his mouth off, you really can't, you hold him in contempt, they can pay a fine. You're not probably going to put him in jail for it or in a cell. What can you do? How do you handle something like this?
Well, as far as I've heard, the judge has not issued any sort of gag order that would prevent people from being able to talk about cases. Prosecutors and defense attorneys often give press conferences talking about their view and their version of what they believe the case and the facts are. So unless there's been some prohibition by the court, they're free to do so. Now, is there going to be a gag order issued? Who knows? I doubt that it would happen in this particular case. It doesn't happen that often in that many cases. And so he's free to discuss and talk about whatever he wants to outside of the courtroom. Now, to your earlier point, if he starts making things that sound like threats, then that could be problematic, and that could land him in trouble with the court. There is a remedy for the court to take, and that is if there is an actual threat against a sitting prosecutor in a case that is ongoing, the judge can hold somebody in contempt and can jail them. So I am surmising that his lawyers are advising him to be very careful about the words that he chooses and the things that he says, to hopefully not have any of them look like they are making actual threats against either the prosecutor or the court, or even the grand jury or any potential jurors that might be involved in this case.
My understanding of it is that the judge did not admonish Trump, but he warned them all to tamp down their rhetoric, not to make statements that would incite any violence. Well,
and I would think that that would be good advice in any situation like this, and not just in a case that is potentially this volatile in nature.
Judge, we hear in a few weeks there may actually be the beginning of a trial for a rape case involving Trump. There may be a devaluation of assets trial that's coming in October 2nd. It's supposed to start. Also a civil trial. What do you think is the impact of all of these cases coming? Does one impact the other? Can they all stand separate and on their own? Your thoughts?
I think that they all do have to stand separate and on their own. I think it would be unfair for one to necessarily have any impact on the other. They're separate issues, they're separate cases. They need to be considered independently of each other.
But as these fall, though, I'm thinking jury pools and perception and understanding of it, and they're staggered, and they're going to be coming in as different moments happen. Can there be a ruling where you say one has to finish before the next begins, or can all of this just pile up?
Well, I mean, obviously, none of the cases can be tried at the same time, and they would have to coordinate the schedules to make sure that there wasn't any potential overlap in the trial settings or the dates that somebody has to be called. The way that I've always handled it is whoever gets you first gets you first. So if he's already caught up in trial and someplace else, then you just, even if you have a trial setting on your docket, you have to wait your turn. You can't make somebody be in more than one place at a time. But who knows how all of those other cases are going to work out. To one of your earlier questions in terms of prosecutors only wanting to pursue cases that they think that they can win, that's sort of the norm. They want to pursue cases that they have a good likelihood of being successful in. Here in Houston, we have about a 95% plea rate on cases that are prosecuted. So that tells you that those are cases that they think that they're going to win and that they usually do win. So we'll have to see how it all plays out.
Judge, thank you so much. Thank you for joining us today. Vanessa Gilmore is a retired U.S. District Judge, and Dr. Frank Sorrentino is the author of Presidential Power and the American Political System.